Hello everyone, welcome to Drishti IAS. You're watching the NCERT Foundation Series and today we are going to cover some crucial concepts about the Indian judiciary, primarily the Supreme Court, with the help of PYQs mainly. And without further ado, let's plunge right in. So let's begin with the previous day question. I had asked you the power of the Supreme Court of India to decide disputes between the centre and the states falls under its A. Advisory jurisdiction, B. Appellate jurisdiction, C. Original jurisdiction, or D. Writ jurisdiction. And this question was asked in 2014 UPSC prelims paper. So before attempting this question, let's try and understand the kinds of jurisdiction that the Supreme Court of India possesses. Please note that the Supreme Court of India is one of the most powerful Supreme Courts in the world, anywhere in the world. So, the Supreme Court is empowered with 4 types of jurisdiction, beginning with the original jurisdiction. Now, as the name suggests, it is called original jurisdiction because Supreme Court can take cases here without the process of appeal, which means that the litigants can directly approach the Supreme Court and not necessarily by means of appeal from a lower court. All right. And this particularly deals with federal matters. So, the Supreme Court under its original jurisdiction deals with matters of federal importance, meaning it deals with matters or disputes between centre and states, between states and states, and between centre and states on one side versus other states. So these are the 3 types of cases or the 3 type of disputes that the Supreme Court under its original jurisdiction deals with. Now it is known as also original jurisdiction. Why? Because these matters are dealt exclusively by the Supreme Court. No other court, no lower court, including the High Court, can deal with these matters. So there goes your original jurisdiction. Other than this, there is also the appellate jurisdiction. Now, as the name suggests, when we are talking about appellate jurisdiction, it derives from the word appeal. So, of course, the Supreme Court admits cases against any lower court by means of appeal. Now, it may admit cases to itself from a lower court provided the High Court certifies that the case is fit to be admitted to the Supreme Court. However, of course, Supreme Court can exercise its discretion in matters of whether the case ought to be admitted or does not ought to be admitted. All right. So this has to do with appeals. Now, in matters of, let's say, criminal nature or in criminal matters, whenever a lower court gives a sentence of death to anybody, then the Supreme Court may also take that matter. All right. So, in case of a death sentence, the appeal may be made either to the Supreme Court or the High Court. This goes with the second type of jurisdiction, which is the appellate jurisdiction of the Supreme Court. Then there is the writ jurisdiction, and we have discussed this particular jurisdiction of the Supreme Court in sufficient detail while we were discussing the fundamental rights. Now, here the thing is that the Supreme Court exercises its writ jurisdiction under Article 32. And the Supreme Court can issue writs only in matters dealing with the violation of fundamental rights. Whereas when it comes to high courts, high courts exercise their writ jurisdiction under Article 226. Alright, and not only do these writ jurisdiction of the High Court confine itself to matters pertaining to fundamental rights, but also other matters as well. And therefore, the writ jurisdiction of the High Court is wider as compared to the Supreme Court, or the writ jurisdiction of the Supreme Court is relatively narrower as compared to the High Court. Now, what could be the other matters? It could be, for example, property matter, or let's say land disputes. All right. And finally, there is this fourth kind of jurisdiction, which is called the advisory jurisdiction. Now, in the comment section, you have to tell me the articles related to one or all of these type of jurisdiction. At least tell me the article which is related to the original jurisdiction, because that also happens to be a favorite of UPSC. UPSC does twist around things and then come to one or the other form of jurisdiction, and mainly I think it is particularly fond of the original jurisdiction. So please let me know the article number dealing with the original jurisdiction of the Supreme Court in the comment section now. So now, as the name suggests, while we are dealing with the advisory jurisdiction of the Supreme Court, of course it means it has to tend advice. Now, who asks for its advice, and when and why? So the President of the India may ask for the advice of the Supreme Court when, if it is a matter of great public importance, right? So if the matter is of public importance, then naturally the Supreme Court would be called to tend its advice to the presidents, or if it involves the interpretation of Constitution. So if it involves the interpretation of the Constitution also, the Supreme Court may be called or requested for advice. Now, what is interesting is to note that the advice of the Supreme Court is not binding. It is not binding. But what about the Supreme Court? Do you think the Supreme Court is bound to tender its advice? Here again, the Supreme Court is not bound to tend advice. All right. So here again, the Supreme Court is not bound to tend advice, as well as the President is not bound by the advice if given by the Supreme Court. So these are the four types of jurisdiction. Now, what are the advantages of the advisory form of jurisdiction? So with this background in mind, let's go and attempt our question. So, the power of the Supreme Court to decide disputes between the center and the states naturally fall with the original jurisdiction. So, option C is your correct answer, and quite a few of you have answered it correctly even in the comment section. Which of the following are included in the original jurisdiction of the Supreme Court? Again, fairly straightforward. The question was asked in 2013. Now, all of this information is also available in your NCERT, and hence reading the NCERTs line by line is very important. Also, its concept clarification is fairly important before you move ahead to more advanced books. All right. So here we've already talked about the original jurisdiction. One, a dispute between the government of India and one or more states. Of course, This is correct. Option 2 says, or statement 2 says, a dispute regarding elections to either house of the parliament or that of legislature of a state. This is not included in the original jurisdiction of the Supreme Court. Third says, a dispute between the government of India and a union territory. This again is not included. And option or statement 4 says, a dispute between 2 or more states. And this we did in fact discuss was a part of the original jurisdiction of the Supreme Court, and hence 1 and 4 are correct. Therefore, option C is the correct answer. I hope this is clear. It was a fairly straightforward question once you understood the concept. Consider the following statements. Again, a PYQ of 2020. Statement 1 says, the Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Now, one may be very tempted to mark this as correct because, of course, these are the elements of the basic structure of the Constitution. But please read carefully. The statement says the Constitution of India defines. Now, here's the catch. The Constitution of India does not or has nowhere defined the basic structure. All right? The basic structure doctrine has been evolved. It has been evolved. By whom? By the Supreme Court. It has been evolved by the Supreme Court. And when? It was evolved in the landmark Keshwananda Bharati judgment of 1973. So, Bharati judgment of 1973 is landmark. Why? Because it is here that the Supreme Court of India evolved the doctrine of the basic structure of the Constitution. Now, of course, basic structure of the Constitution simply means that the Parliament, using its powers, amendment powers under Article 368, cannot amend the basic structure. This also means that the amending powers of the Parliament under Article 368 are not absolute. They are not absolute. And they cannot alter the basic structure. The basic structure itself includes elements that we just read about. So, rule of law is there. There is judicial review. There is, in fact, federalism, democracy, and all the elements just discussed in the statements. So, while all of these do form the basic structure of the Indian Constitution, the Constitution itself has nowhere mentioned basic structure explicitly. All right? So, yes, federalism is there, secularism is there, fundamental rights, democracy, judicial review, all of these form indeed the basic structure of the Constitution. The second statement says the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Now, does the Constitution provide for judicial review? Here again, although the Constitution does not explicitly provide or use the term judicial review, but it does in fact provide for judicial review in various articles. In fact, judicial review is actually one of the elements of the basic structure of the Constitution. So, various articles like Article 13, the primary source of judicial review, along with, of course, Articles 32, which is the right to constitutional remedy, Article 226, all right, and the various types of jurisdiction of the Supreme Court that we have talked about. They also contain all the elements of, for example, the appellate jurisdiction. They also contain, or even original jurisdiction, they also contain elements of judicial review. Explicitly, of course, judicial review can be derived from this. So, again, here, see, there is a difference between the two statements. Here it says Constitution defines. Constitution has not defined, hence the statement is incorrect. Had it said something similar here, we would have also marked this statement as incorrect. But it simply says that the Constitution provides for. Yes, the Constitution does in fact provide for judicial review, and hence we are going to consider the statement correct. So, only two, and therefore option B happens to be our correct answer. I hope this is making sense. Now this question says, again a PYQ from 2016, it says in India, judicial review implies what? Now what exactly does judicial review mean? Judicial review simply means that the Supreme Court may examine the constitutionality of any act of the government or the legislature. So, judicial review means that the Supreme Court will examine the constitutionality of what? The constitutionality of any legislative enactment. When we talk about legislative enactments, we are mainly talking about laws. So, legislative enactments is one thing. What else? It also talks about executive orders, orders of the government. So, not only laws, but even the constitutionality of the executive orders is examined by the courts. Here again, they have to see what exactly? They have to see three things, and they are that first, these should not be in violation of fundamental rights. So here, if the fundamental rights are violated, the law or the order is considered void. All right. Again, the law or the order should not exceed the legislative competency of the authority that has framed them. So, the authority that frames or passes these orders should do so within the purview of their competence, all right, within their own domain. They should not exceed that authority and do so. Otherwise, it will again become violative of this provision. And finally, the basic structure of the Constitution should not be violated by either of the law or the executive order. In case all of this is violated, then the act or the order is considered null and void. All right, it is declared null and void. So, it should not be in violation of the fundamental rights, it should not exceed the legislative competence of the authority that frames it, and it should not violate the basic structure. So, that is what is meant by judicial review. So, with the help of this, let's go back to our question. Option A says the power of the judiciary to pronounce upon the constitutionality of laws and executive orders. This is absolutely correct. Let's also check other options out in order to rule out any confusion. Option B says the power of the judiciary to question the wisdom of the laws enacted by the parliament. Notice the word here, wisdom of the laws. This means it is talking about the merits or policy decision. All right. Now this, the judiciary cannot do. What the judiciary is concerned with is whether the law is not violative of the three conditions that we have mentioned. It cannot go into the reasoning or the grounds or the merits of the decision of the parliament, and this ensures that there is a separation of powers that has been mentioned in the constitution. So we can rule this out. The third statement says the power of the judiciary to review all the decisions of the subordinate courts. Now this forms a part of what we just discussed, the appellate jurisdiction. All right. So if we talk about the Supreme Court, we are actually referring to the appellate jurisdiction while talking about reviewing the decisions of the subordinate courts. That is why the cases are admitted to the higher court by way of appeal when the review of a decision of a lower court is mandated or required. So this can be ruled out. D, the power of the judiciary to review its own judgments given earlier in similar or different cases. So for example, particularly Article 137 talks about this. Please go check out Article 137. All right. And it says that the Supreme Court has the power to review its own decisions. Now that can be done by means of a review petition and further ahead with the means of a curative petition. All right. But this again does not mean judicial review. Judicial review particularly means this, which is your first statement and also the correct answer, that is option A. Again a PYQ. Consider the following statements regarding the public interest litigation or PIL in India. What is PIL? We have discussed it in one of the previous videos. Kindly do go check that video out. And here when we talk about PIL, it basically means legal action that is taken by someone or legal action that is filed in the court by someone who is not directly affected by certain problems or certain grievances, but is a public spirited person, someone who is affected by the grievances or issues or problems of somebody else or a group of other people who are suffering. For example, laborers or old age people or women, all right? So if such a legal action has to be admitted to the court, the instrument that may be used is known as PIL, which is public interest litigation. It is also known as SAL, which is social action litigation, or SIL, which is social interest litigation, or also CAL, which is class action litigation, primarily because it deals with a class of aggrieved individuals who cannot themselves represent their issues or grievances to the court. All right. So on their behalf, someone who's public spirited may appear or may file a case. Now, what this public interest litigation does is that it removes the condition of locus standi. What does locus standi mean? Locus standi means that somebody who is aggrieved may approach the court only. So only the aggrieved person has to approach the court. What PIL does is it relaxes this condition of locus standi. Therefore, anybody, any person, any public spirited person is able to approach the court on behalf of somebody else. All right. So this is the main, let's say, brief about PIL. Now, PIL here in India started in the 1970s and it is considered as a part of judicial activism. Not a part of judicial review, but rather a part of judicial activism. Who are the judges that are associated? Who are the judges that are associated? I'll give you the name of one and you have to give me the name of another judge who is associated or who are considered as pioneers of judicial activism and therefore PIL in India. One of them is Justice Bhagwati. You have to give me the name of another in the comments section. Alright. Now with this information in mind, let's try to solve our question. So with this information in mind, let's try to solve our question. So regarding PIL, the statement 1 says it allows any person to file a petition in the Supreme Court or High Court on behalf of those whose rights are violated. This statement is accurate as we have just discussed. Of course, any public spirited person may represent those people whose rights are violated in court and who cannot somehow for some reason manage to file a petition in the higher courts. And this relaxes the condition of locus standi. Okay, the condition of locus standi is relaxed. The second statement says the concept of PIL was introduced through a constitutional amendment. This statement is incorrect. There was no constitutional amendment that was enacted to introduce the concept of PIL, but rather this was developed and evolved over time by the judiciary itself. And we did mention the judges involved. Statement 3 says the Supreme Court has used PIL to expand the scope of Article 21. Now, what is Article 21? Article 21 deals with a fundamental right. What is that fundamental right? It is the right to life and personal liberty. Now, has PILs actually expanded the scope of this right? So, think about the PILs, for example, related to environment. So, there have been various PILs that have dealt with environmental issues. And of course, Article 21 has been expanded to include the right to a clean and sustainable environment. And this is just one example. Think about other things like right to, let's say, the sufficient livelihood, all right, for that matter. So, here, this statement happens to be correct because we can see by means of an example or various other examples actually that the scope of Article 21 has been expanded thanks to PILs. So, this statement is correct, which makes option A our correct answer, 1 and 3 only. Now, this again is a PYQ that was asked this very year, and this is not exactly absolutely related to this chapter, but it is actually a summation of a lot of chapters that we have or a lot of topics that we have already covered. It's fairly straightforward. So here provision in the Constitution of India has been given along with the part or the provision that they have been stated under. Now the first one says separation of judiciary from the executive in the public services of the state. Separation of judiciary from the executive. Which article deals with this? So it is dealt with Article 50, and of course it is a part of the directive principles of state policy. So we can see that this is accurately matched. The second provision talks about valuing and preserving the rich heritage of our composite culture. Now the rich heritage part is actually being discussed in the fundamental duties, which is Article 51A and provision number F. So this again here is accurately matched. Now, prohibition of employment of children below the age of 14 years in factories. It says fundamental rights. It is absolutely correct. We are here dealing with right against exploitation. Now, in the comment section, you have to tell me which is the right, which is the article that is talking about prohibition of employment of children below the age of 14 years in factories, you have to tell me the article number in the comment section. So now consider the following pairs. How many of the above pairs are correctly matched? And we can see that all three of the pairs are correctly matched, and therefore option C is your correct answer. So before we move ahead, I request you to please go ahead and check out the NCERT online course for your UPSC Foundation. The course provides 150 plus classes and comes with a validity of 2 years. And for more information, you can check the link in the description box, or you can call 87501. So now again, I have brought for you a previous year's question as practice question. Kindly look at the question carefully and attempt to solve it. If you found today's video fruitful, kindly like, share and subscribe. Do send me your answers to this question in the comment section. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.